Good morning, ladies and gentlemen. Welcome to the Public Service Commission of South Carolina. Today is Thursday, September 16th, 2021. It's approximately 10 a.m. We're here in the matter of 2021 89E and 2021 90E, the Duke Energy Progress, Duke Energy Carolinas avoided cost proceeding. Before we begin, let's take roll. Present in the hearing room, we have Commissioners Thomas C. Williams, Powers, Belzer, and Jay Williams. Joining us virtually, we have Commissioner Irvin and Commissioner Caston. So today, we're going to call the independent third-party consultant, the president of London Economics International. Before we call Mr. Golden, are there any matters that we need to discuss before we proceed?
Mr. Chairman, this is Frank Ellerby for Duke Energy Carolinas and Duke Energy Progress. As indicated by the letter we sent to the Commission last week, we have not submitted any testimony responding to the London Economics Report and don't expect to have any questions this morning for Mr. Golden. I'm taking a minute just to say thank you to the Commission for giving us the opportunity to review the report and the opportunity to consider whether we needed to file testimony responding to it. We think that's really important. We think the Commission did the right thing in providing a process so that the parties could see the report and have an opportunity to respond to it. We're glad we don't have to. We're glad that the report supported the stipulated agreement, but we did want to make it clear that we thought it was important, and we appreciate the fact that y'all gave us that opportunity. So thanks very much.
Well, I appreciate those kind words, Attorney Ellerby, and I think the staff at the Commission appreciates them as well. Okay, so is there anything else from any party? If not, Mr. Goulding, if you would, please take the witness stand.
Thank you.
All right, sir, if you could please raise your hand, right hand, and be sworn in by our court reporter.
Do you solemnly swear or affirm that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth?
Yes, I so affirm.
Thank you.
All right, sir. Could you state your full name, please?
Yes, my full name is, my full legal name is Jonathan Arthur Goulding. I'm commonly referred to as AJ.
Okay. And Mr. Goulding, if possible, could you increase the volume or talk closer to the microphone? You're a bit faint here in the hearing room.
Is this any better?
It's
I know the
perfect.
visual's not great.
That's perfect.
Wonderful. Okay.
All right, sir. Okay. And who do you work for, sir?
I'm employed by London Economics International, LLC. I'm also employed by Columbia University.
Okay. Outstanding. Would you place or would you summarize the findings in your independent report on Duke Energy Carolinas and Duke Energy Progress in dockets number 2021 89E and 90E?
Yes, we reviewed the submissions of the applicant and examined both the level of the avoided cost findings along with the proposed minor changes to the accompanying documents. Over the course of that analysis, we found no evidence that would suggest that the proposed settlement was inequitable or inconsistent with our own calculations, and thus we recommend that the settlement be approved.
Okay. Could you speak to some of the recommendations that you made in the report?
Certainly, and let me turn to the page 49 in my report.
Okay, and so that's page 49 of your
Of the report that's entitled Independent Report on Duke Energy Carolinas LLC and Duke Energy Progress LLC's 2021 Avoided Cost Proceeding, dated August 23rd, 2021.
right, and this report was filed on DMS, right?
Yes, it was.
Right, and just want to make sure all the parties have a copy of the report. Okay, I think everyone has a copy of the report. All right, so page 49, sir.
Yes, so we've included a text box that is entitled LEI's Overall Opinion of DEC and DEP's 2021 Avoided Cost Proceeding. There we state first that the proposed Schedule PP and large QF tariffs accurately reflect DEC and DEP's avoided costs to the extent allowed by the modeling. And so as we discuss in the subsequent draft, the approach that we took was to attempt to replicate the numbers using our own models and looking at our own reasonable assumptions. And in the course of those calculations, we found that we could come to numbers that were generally within 5% of those proposed by the company. And we felt that that was well within a zone of reasonableness, given that any particular model is driven by its assumptions, and that over the long term, various models can have results that are within 10% of the actual outcomes. Sometimes they vary by more. So we felt that the fact that our model produced results that were similar to those of the applicant was sufficient to substantiate the idea that the proposal was reasonable. Our second conclusion was that the terms and conditions included in the proposed standard offer PPA, standard offer terms and conditions, large QF PPA, and NOC form are commercially reasonable and remain consistent with PURPA. We noted that the documents were largely unchanged and were consistent with versions that were previously approved, that the proposed changes in some cases were represented to be at the request of stakeholders rather than the company, and that overall they met the commercially reasonable standard. We further compared the documents to other standard documents that are proposed by industry groups. We found that they were similar, and we also examined the minimum contents of those documents consistent with the various laws and regulations, and we found that they were appropriate. Our third recommendation was that, or our third conclusion rather, was that the proposed avoided cost methodology fairly accounts for DEC and DEP's avoided costs. We noted that the methodology was the same as was used in prior filings. We noted that the methodology itself is one that is broadly applied across the industry in similar proceedings. um, and that the methodology was applied in a consistent way. Um, we also agreed with the modification in the seasonal allocation for DEC's capacity payments, as recommended by the ORS witness, and acknowledged that the proposed modification ensures that capacity costs are allocated in a way that better reflects expected system needs. Ultimately, based on those three conclusions, LEI recommended that the commission approve the proposed stipulation.
Thank you, sir. I want to talk about considering risk holistically. What are your thoughts regarding the risk or reducing the risk placed on the using and consuming public based on the information you reviewed in this docket or these dockets?
Well, that's an interesting question, and I think that one of the challenges when we think about risk is sometimes that's interpreted as simply reducing costs. I'm not convinced that that is a sufficiently complete consideration of what constitutes risk. And we see a lot of discussion about how historically there have been PURPA contracts that resulted in costs that, with the benefit of hindsight, were higher than what the utility could have obtained subsequently. And certainly that's a concern. Contracts today that are on offer are generally shorter than those that were offered in the beginning years of PURPA. South Carolina offers a 10-year contract. And that certainly helps to avoid the potential to overpay based on, if you believe that the world consists of ever-declining fuel costs, ever-declining technology costs, and low inflation, then shortening the contract term makes sure that you don't lock in prices that will prove to be higher later. But the current environment is surely one of the most dynamic that we've seen in the electric utility industry, and one of the most uncertain with regards to the overall economy. And so I think we need to be conscious of the fact that the historic decline in natural gas prices may be coming to an end, and that the declines in the cost of various technologies may be flattening out, particularly solar PV. Batteries has a ways to go. And so we also need to be mindful when we consider risk that we also consider the fact that we may end up under contracting if we enter a world in which the fuel price and technology cost dynamics are changing. I think that the other thing that we need to be mindful of is balancing the talents and advantages of utility system coordination against the need to have multiple suppliers against which you can benchmark costs and performance. And so I think that the ability to continue to contract with third parties allows you to access some critical information and provides for the development of a robust independent power industry that can serve as a check on the utility. But ultimately, we have to make sure, first and foremost, that what we're doing is in the interest of the customers. And so I believe that ultimately the stipulation itself strikes the appropriate balance, and that going forward, we need to monitor developments in technology costs, fuel costs, and new ways of organizing the system, the role of distributed energy resources, the role of demand response. All of these things are going to have an impact on how we manage the risk to final consumers.
Okay, understood. Thank you for that, sir. So I appreciate your testimony, sir. I think you laid out your report well. I'm going to go ahead and enter your report, the independent report on Duke Energy Carolinas LLC and Duke Energy Progress LLC's 2021 avoided cost proceeding in dockets number 2021-89E and 2021-90E. Enter that, mark it, and enter it into the record as hearing exhibit number 7. Is there any cross-examination for this witness?
No cross-examination on behalf of the Duke companies, Mr. Chairman, although we would reserve the right to ask any questions based on commissioner questions if the need arises. So thank you for your report and your appearing here today, Mr. Goulding.
Johnson Development Associates. Carolina.
Good morning, Court Walsh here. No questions for this witness. Thanks.
Yes, sir. Carolina's Clean Energy Business Association.
Mr. Chairman, Rich Witt from the Witt Law Firm here for Carolina's Clean Energy Business Association. No questions.
South Carolina Department of Consumer Affairs.
Connor Parker here on behalf of the department. No questions, Mr. Chairman.
South Carolina Coastal Conservation League and Southern Alliance for Clean Energy.
Emma Clancy here for CCL and SACE. No questions.
All right. Office of Regulatory Staff.
Good morning, Mr. Chairman. Alex Knowles for ORS. We have no questions, and we would respectfully reserve the right to ask questions in response to commissioner questions as well. Thank you.
All right. Fellow commissioners, questions for Mr. Goulding.
Mr. Chairman.
Commissioner Thomas.
Thank you. And thank you, Mr. Goulding, for being here to go over this with us and answer our questions. So I guess basically I have one kind of a high-level question, and that relates to the inability of staff or commissioners to communicate with you throughout this process, which I understand is part of the law, the way the law works. But just wanted to get your reaction to, is that normally the way this works when you're involved in a project like this? And also what kind of an impact, if any, did that have on your work?
That's an excellent question. This is certainly a unique set of arrangements with regards to the restrictions on the way in which we can communicate with parties and with the folks that sign our engagement letter. I just want to confirm that you can hear me because I'm now seeing myself twice here on the screen. So can you confirm that you can hear me?
I can hear you quite well, and I see you twice, and you look wonderful.
I would say that two of me is far too much, but we'll keep going here. I would say that it would not harm our independence to have the ability to have a little bit more communication with the commission or commission staff, just with regards to things like the form of the report, or to be able to interact a bit more on timing or the calendar. We've worked in a variety of settings where sometimes you have very limited interaction with the client, and that certainly gives you a level of I would say we are always independent, sometimes to our clients' chagrin, but the hands-off approach that is mandated in South Carolina certainly assures that there's no indirect or unconscious influence. But it does, in some ways, make our work a bit more challenging just in terms of various administrative aspects.
Okay. And kind of sort of related, I guess, is your inability to get a hold of the redacted information to utilize in your calculations. I've not matched up everything to the real numbers, but the ones that I have looked at, your estimates look real good. But I guess not being able to access that information probably has a little bit of an impact on the way you go about your work. And I wonder if there's a way that we could give people such as yourself in this sort of a situation access to that. And what I'm thinking about is perhaps if that could be part of the engagement contract, where sign off on you all being able to get access to that, subject to keeping it confidential. And I'm not an attorney, so I don't even know if that's possible, but it's just a thought. Any reaction to that?
Yes, and first of all, I would in no way want to cast aspersions on the applicant in this particular case. We took the view that the timing was too tight based on the statutory time to respond, so we did not ask interrogatories, and I'm sure that the company would have been responsive had we requested them. But I think that obviously examining the redacted information is helpful to show that the ranges and assumptions are reasonable. But I also think that the fact that we were able to develop results that were consistent with the companies suggests that they weren't doing anything particularly unusual. So I know in our report, for example, we highlighted that it would be good to have a better understanding of the volume discount that was applied based on the way in which the company pursues construction of peaking facilities. But at the end of the day, in this particular case, our conclusions suggest that there's nothing particularly anomalous about those calculations. That said, I agree that if there are ways to facilitate exchange of documents through combining the confidentiality agreement with the engagement letter, I think synchronizing the timings just a little bit. It's not that we need days and days to examine the material once it arrives, but if somebody has 20 days to respond and we only have 20 days to do our report, that makes things a bit more challenging, even though in practice people respond more quickly. So I hope that answer is helpful to you.
Yes, and I think one thing that I heard, and I guess just a little bit of clarification here, the timing as much as anything had to do with getting this information. And so I guess what I'm asking now is that if the timing had permitted, would you have been allowed to ask for redacted information? And do you think you would have received it if you had asked for it? And again, I'm just trying to understand, is this more of a timing issue or a contract issue or just the way things work?
I think it's a timing issue. And I think that, if in this particular case there'd been even, an additional 5 days in the schedule, then we probably would have been able to ask the DRs and gotten a response. So I think it is timing. It's certainly, I would also note that, these processes are somewhat iterative in the sense that you need to dive into the material before formulating the questions that you would like to ask. That means that you do need a little bit of time after the engagement letter is signed to pull those questions together. But generally speaking, I think it is something that can be resolved. I do believe that with the signing of a confidentiality agreement, the information would have been provided. I think that if we have a recommendation in this instance, it is to encourage applicants to, wherever possible, come up with a way of presenting information that means they don't have to redact it. So from my perspective, if somebody says, I'm just giving an example, we contacted 5 turbine manufacturers and the results we received were within the range of X to Y with an average of Q, we'd say, hey, that's great. And none of that information in and of itself is confidential. And we understand that sometimes that's just not practical. But we would just like to encourage that when companies are doing their applications, that they try to find ways of presenting information that means that the redactions aren't necessary to begin with.
Okay, so that would be a suggestion for an improvement for future proceedings. And so, given that you've gone down this trail, do you have any other suggestions for improvements in the future?
Well, I think on the one hand that the process, other than the timing, is fairly straightforward. I would also say that 2 proceedings can have the same process and have very different outcomes depending upon the attitudes of the various people and companies involved. And so I think that the most important across the board recommendation is, and this is going to sound like, I don't know, sixth grade math or something is, you know, make a sincere effort to show your work, right? And this is certainly not a criticism of the applicants in this particular proceeding, but I think that it is important that in as much as possible, stakeholders be able to follow the company's reasoning, ideally without having to ask DRs. And so that is, I would say, just part of making good faith filing. But in terms of thinking about procedure, I think that ultimately, you know, as an independent consultant, you know, we have the opportunity to ask all the questions that we need to. I think we just need to be careful to make sure that we're, you know, following the rules with regards to ex parte. You know, even if it's something as small as saying, you know, does this file say what I think it says? You know, that's a you know, a minor constraint in this particular process.
Okay. Let me ask you a specific question in connection with your report. I was looking at figure 19 on page 32 and comparing that with figure 12 on page 28, and there's a difference in the cost, the peaker cost versus the installed combustion turbine cost. Can you tell me why that difference is there?
Just give me a second here. So we're looking at figure 16, and can you remind me what the other figure was that you wanted me to look at?
Okay, I think I meant to say figure 19, which is on page 32 as I see it, and comparing that with figure 12 on page 28.
Just a second, because our page numbers aren't aligning here. I have my figure 19 on page 35, and I'm wondering whether you're talking about figures in what I'm looking at, and I apologize.
Okay, no, I apologize. You're right. It is figure 16 on page 32.
Figure 16 on
wrote
page 32.
my note incorrectly.
Okay, and then the other one that you asked me to take a look at was on, I believe, earlier in the document.
Yeah.
It's page 12.
Figure 12.
Figure 12 on page 28. Okay.
Yes, sir.
And so I think what you're asking me is, why are we starting with 163,727 on figure 12 versus 154,338 on figure 16?
Yes.
Is that correct? I think that what we're looking at here is that the starting point, figure 12 was intended to start the process of backing into the numbers that were in the filing, and then figure 16 was intended to show what our independent starting point would be. And so I apologize if that was unclear. What figure 12 is saying, all right, well, we've got the endpoint, and let's work back to think about what we think the inputs are that weren't disclosed. And then figure 16 is, well, let's, if we start from the top and go down rather than from the bottom and go up, what's our starting point? And so I understand that may have been a little bit unclear from the report.
That's very helpful. Thank you. I appreciate that. And just at a high level, is there anything in the stipulation that is cause for concern in your opinion?
Well, I would say that we place weight on the fact that the stipulation was proposed as a settlement among a group with disparate interests. And while we realize that, ultimately the individual customer has no voice, and that as a regulator, you have to look carefully at a settlement to make sure that those that aren't a party to it are not being harmed, we don't see evidence that this stipulation would harm customers. So I think that, no, we don't have a concern over individual aspects of the stipulation.
Okay. Thank you. I appreciate that. That's all I have at this time.
All right. Any more questions from commissioners? Commissioner Powers.
Thank you, Mr. Chairman. Good morning, Mr. Golding. Hope you're doing well.
Thank you.
Can you hear me okay?
I can. I keep having to remind myself to put my fist in front of my face here so that you can have the microphone and hear me. Can you hear me okay?
I certainly can. And my question is very general. We, of course, are concerned on the effect that this has on the ratepayers, and that this certainly conforms with Act 62 that we're operating under, and I know you're very familiar with from reading your report. Is there anything in this stipulation that that you have a problem with, and I guess the real question is, do you feel this is in the best interest of the ratepayers and that we should, as a commission, approve this stipulated agreement?
Yes. So I think I'd like to make an observation, which is I think that one of the advantages of the process in South Carolina is that these rates are assessed every 2 years. And so if circumstances change, then the commission has the opportunity in a relatively short time period to correct. And I would also say that the interesting thing about an avoided cost filing is that we're looking at the utilities avoided costs, and we're making our best estimate of the impact of substituting a PURPA contract for something the utility would otherwise have done. And so in theory, if everything is calculated properly, the customer should be indifferent. Now, we know that everything is based on estimates. Estimates can be wrong. But I would say that in general, looking at this from the perspective of a developer, these rates are not going to result in a gold rush. with regards to folks, beating a path to South Carolina and building lots of new projects. So, if we were to compare these with what developers would be seeking, I think that you're not in a circumstance where there's going to be an imbalance, where the avoided costs have some flaw in them, where they provide an unreasonable surplus to a developer. And so I think that's the circumstance in which customers would be harmed, right? So the rates are calculated, and in fact, they're much higher than the actual avoided cost, and they result in a significant amount of contracts being signed, locked in for 10 years at rates that are higher than they should be. But I mean, I think it's worth identifying that the way that the rates are developed, there are years in which the applicant has identified that the avoided cost is zero, right? There's no need in the system. And that those calculations have been embedded in the 10-year numbers, for example, right? And so I think that the customers, in terms of costs, are protected. And to the extent that these rates cause some continued construction by third parties, that construction should make some contribution to the overall reliability of the system, provided integration costs have been considered.
One of the requirements of Act 62 is that it minimizes the impact to non-solar customers as far as subsidizing solar customers. Do you think this stipulation achieves that goal? It's always quite a struggle as to where that should land. Do you think there's anything that could be done differently that to reach that goal?
Yeah, well, and I think it's important to distinguish between the PURPA universe and the net metering universe, in that our building shuts the lights off periodically because they think there's nobody here. So I apologize if that happens again. Somebody will go out and push a button. I think one of the things that's most challenging about net metering programs is their potential for intra-class subsidies, and for them to result in the utilities not being fairly compensated with regards to the services that they actually provide. But that's very much a net metering discussion. I think it's less a case here in a PURPA-related discussion, because these are, and I understand that some of them may be distribution connected, but essentially I think about these as a wholesale transaction, as a substitution for a utility constructed project. So I think that the pricing is different, and I also believe that if we accept the theory of avoided cost, and we've calculated it reasonably, that there should not be cross subsidies between one customer and another, nor do I believe that there will be subsidies going between one type of generator and another.
So you find this all to be reasonable, the agreement to be
Yes,
reasonable?
I believe that this stipulation is reasonable.
Okay. Well, let me thank you for, not only the help you've given us, but doing so in such a timely manner. Thank you, Mr. Chairman.
Yes, sir. Are there any other questions from commissioners for this witness? Commissioner Williams.
Thank you, Chairman Williams. Good morning. I have a basic question to start out with. Is it Goulding or Golding?
It depends on whether you ask my grandmother or my father.
Oh,
So
dear.
I'm happy with both. Grandmother was a Goulding, and my father's a Goulding. So either is fine with me.
Okay. Well, Mr. Goulding, it's nice to see you again, and appreciate your testimony and the way that you're describing this universe that we're talking about. It is an opportunity for us to learn more about this universe, and so my questions are largely in that spirit. A part of the stipulation is the pricing periods that are proposed going from 11 to 10. And my question is about the reasonableness of that and whether that would negatively impact ratepayers and whether more pricing signals help to signal the actual peak and the off-peak times and to kind of influence use in that way. So I guess the bottom line is the removal of a price period going to impact the avoided cost in a way that leads to under or overpayment?
I don't think so. And I mean, it's an interesting question. You know, in a competitive wholesale market, you effectively have 8,760 pricing periods. And so the price signal is much, much more granular. But on the other hand, having 10 versus 11, I think if we think back in the not too distant past, it wasn't unusual to just have 2 or 4 pricing periods. So certainly having 10 periods provides for a higher degree of granularity. The difference between 11 versus 10, we know that the price signal is averaged over those periods, but I don't think that collapsing one into another based on the observations of load, internal dispatch costs, and hourly reserve margins materially decreases the price signal that's embedded there. As we know, with increased solar penetration, systems are changing rapidly, and our perception of peak is changing as well. Looking at net load, that is load minus solar production, is tending to move the peak later in the day. And having the opportunity to review this 2 years from now is a way of constantly calibrating these pricing periods against actual system operations. And so I don't think that to the extent that things turn out differently than what is embedded in these rates, I don't think that the differences are going to be large. And I also think, as with almost everything in regulation, there's always a trade-off between having something that is absolutely perfect from an efficient price signal versus something that is straightforward to administer and understand. And so I think that I don't believe that there are significant harms from collapsing from 11 to 10 pricing periods. And I think that we do need to consider that if you move to many more pricing periods, you start to have an issue with regards to administration and to the ability of the common ratepayer to understand them.
That makes a lot of sense. Thank you very much. My next question shifts more to the capacity pricing periods and kind of the company going, the impact of the capacity pricing going to the winter time frame versus the summer, and whether that has an impact on ratepayers.
Well, it's an interesting question. And I think on the one hand, if we think about capacity as being caused by the peak, and we look at how the system is changing, then I think that what's been developed here makes sense. I expressed in my submission some concern, as much from an equity perspective, that by shifting entirely away from summer, that we were perhaps not attributing enough value to capacity in the summer months. And certainly when we get back to this kind of net load concept that I mentioned before of the solar production pushing the non-solar peak later in the day, and we also look at the seasonal needs, what's happening in the winter, we can see that these capacity periods that are proposed kind of reflect the changes in the system. And I think that my concern about the signal is it says, effectively it says for new resources, we only care if you show up in the winter. But I also think that that's not really true, right? And that there is some capacity value to new resources in the summer, albeit potentially diminishing. But I think that based on the stipulation, I think that the potential for customer harm is minimal, especially since I imagine that you have relatively few customers that are only summer customers. I mean, we can imagine a few that are only summer or only winter customers, but given that most customers consume year-round, they're going to be paying for the capacity based on their winter usage. So I think that my concern for the customer is not necessarily based on are they paying more, or are some customers paying more than they should and some customers paying less than they should. It is more from the view that there is some small capacity value in summer, and that allocating at least some of the costs to summer signals to generators that they should be available then as well. So I think that's my underlying concern, but it did not rise to the level where I would have said, you should reject this stipulation based solely on that fact.
Thank you. I appreciate the thoughtfulness of how you said it as well. My final question, I believe, is going to be about the forms, and you talked about having looked nationally at other options, and I guess I'm particularly interested in the notice of commitment and how the proposed form measures up, with others nationally and in light of recent PURPA changes.
Well, I think that's an interesting question. I mean, we developed our opinion on, based on three things. One was that this was not an area of substantial disagreement between the company and the interveners. And so if the developer, if both counterparties to a contract aren't complaining about a term, then for somebody outside of that contract to come in and say this is commercially unreasonable, I think there's a pretty high bar. Now, in addition, kind of looking nationally, we didn't see anything that was particularly anomalous. I understand that there's always a tension between the degree of commitment that that a utility thinks is necessary to create a LEO, a legally enforceable obligation, and what a developer thinks is reasonable. But I think in this particular case, we didn't see anything that said, getting back to my discussion about how the regulator has to consider whether there's somebody whose interests have been cut out because they're not at the table. I didn't see anything in this form that meant that customers are going to be, you don't want the LEO to be a free option, right? And that's what happens in some procurements, is that you end up with, sometimes you hear the term bragawatts, folks that on sometimes close to a literal shoestring go in, they get some kind of a commitment, and then they use that to leverage a project. That's not always bad, but what we don't want is the utility sitting around saying, I think these people are going to show up and sign a contract with us, but I don't know, but I have to kind of keep them in the queue anyway. But we didn't think that this notice of commitment was enticing people to have a free option.
Anything to add to that regarding more recent PURPA requirements?
Well, I think that the most recent FERC order gives commissions a great deal of latitude. It provides them guidance as to what they can do. It doesn't say what they must do. The order, I understand that some have interpreted it as providing the opportunity to add additional requirements to the NOC or to whatever equivalent document establishes a LEO. But I don't think that, just because FERC gives you options, it doesn't mean that you have to use all of them, nor does it mandate that you take language from the order and put it into an NOC. So, you know, I understand the basis of the question, but I don't think that customers are harmed if the commission decides not to pursue a particular option that is granted to them by FERC.
I appreciate all of your answers, and it's good to talk with you, Mr. Goulding.
Thank you.
No further questions.
Commissioner Caston.
Good morning, Mr. Goulding.
Good morning.
You hear me okay?
Yes, I can.
Good. I actually had some questions I wanted to ask, but listening to Mr. Thomas Powers and Commissioner Williams' questions, it generated a couple of things. And if it sounds like I'm duplicating it, I apologize. But relative to Commissioner Thomas's and Powers' questions relative to the stipulation, you seem to imply that stakeholder process, not just for this docket, but in general, is a good thing, provided stakeholders are representing all concerned parties, including customers. Did I infer too much from your response?
No, I think I agree with that. I think the way that I have put it is that, you know, stakeholder processes are important. Negotiated settlements, I think, are administratively efficient. The only thing that a regulator needs to look out for is that if there are parties to the settlement, if there are parties that are not party to the settlement, that are affected by the settlement, that their interests are reasonably addressed. Now, in this particular case, there are customer representatives that are involved in the settlement, and you know that are either involved in the settlement or have indicated that they do not object to the settlement. And I think that that's something that, relative to, you know, for example, if you got a partial settlement that was just the utility and the developers, I wouldn't place as much weight on that. Or if you had a settlement that was the utility and one customer class, I wouldn't place as much weight on that. I think a settlement that involves or is not objected to by parties that have a mandate to represent customers would have a higher weight.
Or I assume you're referring to ORS?
Yes.
And in your question and response to Commissioner Williams relative to the winter-summer peak, and I've tried to understand this for some time, and I know it's different relative to electrical utility and, say, a water wastewater utility. But from a planning, design, system sizing point of view, is it relevant whether it's winter or summer? In other words, if the capacity needed, the future designs or looking down the road is based on peak load, does it matter when that peak load is? I mean, I know it may matter, for example, solar, you know, the sun's up longer in the summer. I get that. But I'm talking about from a pure design, preparing for the future to make sure you have enough capacity, generating capacity. Is it or should it be based just on that peak demand or projected peak demand? Or should it be seasonal, and why?
I think that's an excellent question, and it's one that when we look at organized markets, we can see that there are several examples of wholesale markets where their capacity product is an annual product rather than a seasonal product. There are some independent system operators that have a summer and a winter capacity product, and different resources participate in that. But I think you're correct that ultimately the peak, whenever it occurs over the year, is what's going to drive system design. However, what we've also seen is that why the seasons matter is that as we have more and more renewables, intermittent resources, the understanding when a particular type of resource is going to be available then allows you to assess your need. And it may well be that with a particular amount of solar, your system is fine in the summer. And if we had a year-round price signal for capacity, we would, depending on how we structured that, what we really want is for capacity resources that can serve us in the winter, but that price signal wouldn't indicate that. And so I think that from a rate design perspective, it does matter when, over the course of the year, that peak actually occurs. But I also think, in general, that it's important to understand that capacity has value throughout the year from the perspective of who's paying for it. So, I understand that this is not something for which there's a simple yes or no answer. I think that the answer from an economics perspective is that the better that you align your pricing with your need, the more efficient the outcome. But at the same time, what we're seeing is that the systems are evolving fairly quickly, and the question of whether we're now locked into South Carolina being a winter peaking system or not, I think that will not be the case in all years necessarily. So, but to go back to your question, you design the system based on the peak whenever it occurs throughout the year, but having a pricing system that reflects when that expected peak is going to occur helps to provide a signal for the appropriate type of capacity that you need.
All right, let me kind of state back what I think I heard. Is all things equal, generally speaking, that designing for the peak, whenever that is, regardless of date, time, season, it's sensible. It's what you do. You got to know how much you're going to need, independent of when. The seasonal aspect, if I'm understanding you correctly, saying how or why that should should or could come into play is because of the change in market. We need to understand that there are different available resources independent of the utility necessarily. Not always, but it can be. And that those are there, so the system should consider using those resources in the most efficient or effective way, which would be seasonal in some cases, correct?
That's correct. I think I would say it's also about the investment signal. And so if I were to take an extreme case, right, and I said, okay, I think our peak only occurs at 8 p.m. January through March. And I'm going to then take the cost of the resource that I'm using to meet that 8 p.m. need, January through March, and I'm going to spread it over the course of the year. Well, the challenge with that is that you're probably going to end up inadvertently telling the market, hey, we've got a capacity need all throughout the year. And, if you just were to show up for April to December, you'd still get paid, but that's not where the incremental capacity need actually is. And so you could end up sending a price signal that results in investment in capacity that is available at precisely the times that you don't need it. And I think then by concentrated recovery in the hours that you do need it, you're helping to align system needs with what people are actually trying to build.
Okay. And I'm paraphrasing, but I think I also heard you say something along the lines that basically rate structure dictates or shapes behavior.
Yes.
Whether that's investment, whether that's conservation or not. Is that a true statement?
Yes, that's correct.
So what you're saying is if, in that case, 8 p.m. January to March, unless the rate structure is such that, okay, let's say it is that, for the case, then unless there is, let's say there was a great battery design, storage design, which would take care of a lot of issues. Absent that, that 8 p.m. January through March, probably going to need dispatchable resources.
Yes.
So the investment would not drive toward necessarily solar panels, but more toward gas-fired or something else.
Right.
Is that correct or reasonable, Pursuant?
Yes, I think that's correct. I mean, from a PURPA perspective, we can imagine technologies that haven't been developed yet, whether we're talking about using hydrogen peakers or something on those lines, that this kind of a price signal at least shows, this is where we have the greatest need. I think, one of the things that's obviously outside of the scope of this docket is that in terms of looking at demand and demand response, in theory, it would be good if the signals that we're sending to load are the same as the signals that we're sending to generators, right, to new investment. And so what we're certainly saying with these rates for PERPA customers is, this is the time that we have the most need for capacity. And we also should make sure that we're sending the same signals to load that say, hey, that 8 p.m. between January and March, in my completely illustrative example, is when it's most beneficial for the system if, if we have less load. And so, obviously these proceedings are siloed, but there is a relationship.
That makes sense. And if I'm hearing you correctly, I guess as a commission or as a commissioner, as we look at things such as rate structure, these type things, we need to keep that in mind. Peak matters, capacity develop matters, but also the pricing factors that can kind of drive it one way or the other, right?
Yes, yes.
Quickly, I know Commissioner Williams asked you about the NOC, and I assume you've reviewed the proposed documents and forms, including the contract, notice of commitment, and all materials related to the engagement or contracting between the utility and existing or new power generators, correct?
Yes. Our focus in this proceeding is on new generators, because the existing ones would already be contracted under previous forms. So our focus is on the forms that are proposed for anybody that, after you issue your order, shows up, rather than on existing contracts.
I understand. Have you reviewed the PERPA requirements for LEO?
So the PERPA requirements are changing in the sense that the commissions are being given latitude to impose potentially more restrictive terms in a LEO. I think the basic concept still applies, which is you can't show up in a utility's office with a hope and a prayer and say, I'm entitled to a legally enforceable obligation. You have to have some means of demonstrating that you're making progress towards a project. And I think a lot of the debate is over, well, what is reasonable? And I'm speaking generally here. I'm not speaking in this particular proceeding. The parties have agreed to the structure of the NOC, and that's that appears to be commercially reasonable. Now, I think that when we think about the progression from an NOC to a PPA, there's the question of at what point do you impose particular requirements? Because the utility is certainly not obligated to sign a PPA with a vapor project. When I say vapor project, I mean something that has very little substance. But the question of where you are on a LEO, what degree of site control is reasonable, and what's the form of site control that you should be required to show? What level of permits? Where should you be in the permitting process? I think that certainly the most recent FERC order gave commissions a great deal of latitude in terms of what is required for a LEO as opposed to a PPA. I think in this, the NOC in this stipulation strikes me as being a reasonable balance. It's not the only set of terms that could be deemed reasonable. In other words, you know, there's always a continuum on each individual term of things that might be determined to be reasonable. Could you ask for something that was more restrictive based on the recent FERC order? Yes, I think you could. Are customers harmed by not doing that? I don't think so.
So all that, you do agree that purple leaves the determination of whether a LEO exists as a matter reserved to the state regulatory commissions to determine, correct?
Yes, and I do want to emphasize I'm an economist, not a lawyer, and I don't want to be perceived as presenting any kind of a legal opinion. But within certain broad parameters, yes, I agree that there is discretion for regulators, for commissions.
Do you believe, I'll use the acronyms, but do you believe LEO and NOC are interchangeable? Just different words saying the same thing?
Well, again, I would say that I don't want to put on a lawyer's hat here. I am using them to be interchangeable. And I believe that that's kind of consistent with practice in South Carolina. But I wouldn't want to express a legal opinion.
I understand. Finally, I know your focus was primarily on the NOC relative to new QFs, but should new or existing QFs be treated in the same manner, so that there is no preferential treatment? Or in other words, should an existing QF be treated differently, maybe more favorably or less favorably, or the same as a new QF?
Well, I think we have to define terms to a certain extent. So somebody that's already traveled through the process, and so they've had NOC, they've gone through, they've gotten a PPA, they've signed all the documents, the plant is operating. I would say they're effectively following the regulations that existed at the time that they commenced operations. And so that's locked in. I think the challenge, and I worry about opening hypothetical doors here, but you always have the possibility for debates for somebody that was about to enter into an NOC, the rules change, and they say, hey, I had 2 meetings with the utility about my project. And I think that the fact that I had those 2 meetings means that I should be entitled to the rules as they were when I had the first meeting, as opposed to the fact that this new commission order has come out in the meantime. So, that then it raises some procedural issues that I think ultimately the lawyers would be better placed than myself to sort out. I think that what is going to be interesting is that, given the 10-year contracts, eventually you're going to have some existing projects that are going to want to consider recontracting. And I think that at the time that they are looking at recontracting, they have to be held to the laws as they exist at the time that they're seeking that new contract, as opposed to the ones that existed at the time that they entered into their contract. And I think that would extend to, any kind of an NOC. They're going to be in a very different position just by the basis of the fact that they're already operating. It should be much simpler for them to follow the various procedures. But nonetheless, there, I believe, are going to be circumstances where you're going to have some existing projects that come to the end of their contract life that are going to want to be recontracted, and there's going to need to be a level playing field at that time.
Thank you. Final question, I promise. Let me ask your opinion on this. One of the witnesses, and I can't remember who, and I honestly can't remember if it was in this particular bucket or another one, but the discussion was similar to this, qualifying facility, LEOs and such. And he made a statement, something to the effect that he believes that the shape of things to come, the future, will not be like this. NOCs are just LEOs, but and I forget the exact terminology, but in essence, it was like it will be developed for the open market, not just, as a LEO. What is your opinion on that?
Well, I think that's a complicated question, right? And it's very state specific, right? I mean, as long as I think the question is, does a generator in a particular jurisdiction actually have the right to access the wholesale market, right? I mean, we know that we have open access transmission, but we also know. Sorry.
May I interrupt you just for a second? It was a competitive procurement, CPRE.
Yes. Yeah. Okay. So I think, and I hope you don't mind if I make a distinction and then proceed responding to a competitive procurement. So there's what I'll refer to for the purposes of this discussion, complete merchant generation, right? Somebody decides, hey, I'm going to build something. I'm going to go out into the market. I'm going to find a corporate PPA or some other off-taker, or I'm going to sell, if I'm located within the confines of an independent system operator, I'm going to sell into that market. It would be highly unusual to develop a project where you were just taking spot prices, but it's theoretically possible. So I think those kinds of merchant projects are not what you're talking about. I think what you're talking about is that we have the opportunity, and I think you may be, well, I want to make sure that I stay in this docket as well. So I agree that if a state decides that they're not ready or they don't see the benefits of participating in an integrated wholesale market, that regular competitive procurements issued consistent with need in an IRP that are structured in a way that's fair to both utilities and those that would participate in the RFP, I agree that those are probably the way to go. I think that if if you want to see an evolution, which I believe is likely to be PURPA compliant, then I'll leave that to the lawyers. But then establishing a framework for regular competitive procurement consistent with an IRP is the way to go. So I do think that that is increasingly.
Would you repeat that one more time?
Sure.
Would you mind repeating that? It broke up just then.
Yeah, and I apologize. Let me try again, and if I'm not intelligible, please let me know. So I think that for those states that choose not to access competitive wholesale markets, that providing for a series of regular competitive procurements that are synchronized with need identified in an integrated resource plan and that are structured in a way that is fair to both utilities and proponents in that RFP is the way to go going forward. And if that process can be designed in a way that is consistent with PURPA, that is likely a better approach, right? We all don't have to sit here and guess at what future utility avoided costs are. Developers can bid their true costs rather than trying to develop a project that fits within the avoided costs. And you have more control over the capacity and timing that is contracted for. So I would tend to agree that a structured competitive process would be a sound approach.
Okay, that makes sense. So rather than necessarily dictating markets, I'd say, well, such and such a percent of solar, such and such a percent of gas, the competitive process, the market would be based on the needs, the capacity needs, and kind of driven by technology in that respect. Is that correct? Does that make sense?
Yeah, I mean, there's a wide variety of ways you can structure a competitive process, and so you could decide, look, we've identified a future target for the balance between zero emitting and non-zero emitting resources. We identified a need in our IRP. I'm going to make this up, but it's more or less consistent with what we're seeing in South Carolina. We've identified a need for X megawatts of Y technology in 2025, right? And then you go out and you issue a request for proposals for that specific technology. Now, I'm always of the view that you don't want to be too specific in your technology specifications. You want to say, say either I want it dispatchable or I don't care whether it's dispatchable. It has to be zero emitting or it doesn't need to be zero emitting, but beyond that, let the market propose a range of solutions. But ultimately, by setting the terms of what you're willing to contract for, you guide the market in terms of their submissions and you synchronize it with an integrated resource plan.
Okay. And relative to an IRP, and there's been a lot of discussion on IRP, the value or the importance and I'd say the jury's still out on that with some perhaps, but am I understanding you to say that, and generally the IRP maps out, this is the course we think things will go or should go. This is our future plans, but it's still dictated by technology or technology that's available or may not become available?
Well, I mean, IRPs have to be performed based on the known technologies. And, what we put into an IRP today may be different from what we put into an IRP 5, 10 years from now. And I think this is why, as much as possible, the further out you get in the IRP, the more that I would want to describe the need in terms of megawatts, dispatchability, and emissions profile, rather than saying, this is exactly the technology that we need, because that becomes quite limiting.
I understand. It makes sense totally. I've occupied enough of your time. I appreciate your indulgence. Thank you so much, Mr. Wood.
Thank you.
All right, we've been going for about an hour and a half. Let's take a quick break. We'll be back at 11:50. Good morning, ladies and gentlemen. Welcome back to the Public Service Commission of South Carolina. We're hearing dockets number 2021-89E and 2021-90E, Independent Report, a review of the Independent Report on Duke Energy Carolinas LLC and Duke Energy Progress's 2021 avoided cost proceedings. Let's take roll. Present in the hearing room, we have Commissioner Thomas, Commissioner Curley Williams, Commissioner Powers, Vice Chair Belzer, Chairman Williams, and joining us virtually, we have Commissioner Caston and Commissioner Urban. Before we took a brief break, we finished with Commissioner Caston's questions, and I want to ask if my colleagues have any more questions for this witness.
Mr. Chairman.
Commissioner Urban.
Thank you, Mr. Chairman. Mr. Golding, thank you for being with us today, and thank you for completing your report in a record 20 days. I don't know how you did it, but I think given the challenge that you were given and the task you're given, it's an excellent report. I also want to take this opportunity to thank all the parties and the stakeholders and their attorneys, intervenors and their attorneys, ORS and their attorneys for reaching a comprehensive stipulated settlement agreement in these two dockets. I think that this reinforces the importance of the stakeholder process, and to Duke's credit, they have, I think, been very transparent and open and cooperative with the parties, and that's certainly to their credit as well. Which brings me to my first question for you. Do we really need an expert in this case, since there was a stipulated settlement agreement?
I'm not sure that I'm necessarily a disinterested party in answering that question, right?
I understand. I want to ask you to be objective, though.
Yeah. Well, I think there's, I think, two possible answers to that, right? One is, I would say that if you, as a commission, look at a settlement and you're confident that it fairly addresses the needs of all parties, that then, if there's nobody objecting to it, and you feel that the voiceless have not been misused, then maybe an expert independent opinion is not necessary. I think that the benefit of an independent expert is that they can provide additional comfort with regards to the fairness of the negotiated settlement. And so it's really a question. Reasonable people can decide whether they want to buy insurance and to what degree of coverage. And so having an independent expert review a settlement is a form of insurance, and its value depends upon the extent to which there's a need to show that all parties are being treated fairly. So, I realize that's not a yes/no answer, but I think ultimately it's just a matter of weighing. And I know this is an imperfect analogy, so I apologize. But if I go buy a used car, sometimes I might say, you know what? I know the seller. I know they really are a little old lady who only drove it to church. I'm comfortable with that. I don't need a mechanic to go in and look at it to make sure that the claims that are being made are true. And you might take a different approach if it's something that you'd found on online and from somebody you don't know very well. And I mean, those are two extremes, and this circumstance doesn't necessarily fit either of them. But I think the other benefit is that the commissioners all come from different distinguished backgrounds and have knowledge that's relevant to the case. But to the extent that a stipulation covers areas where it's not something that commissioners have day-to-day experience, sometimes it's nice to have somebody come in and say, yeah, this all looks okay. So I think that's kind of where I would come out.
That's a fair answer, and I agree with that answer and that response. My concern, though, is had this been a contested case on one or more issues, the time constraints that were imposed upon you really were not fair to you and your work product, were they?
I would say it would be much more challenging. And again, I want to be careful not to refer to other dockets, but I think that 20 days would be difficult in a highly contested process. I mean,
So is it fair to say that we could learn from this process and perhaps maybe even ask the General Assembly to give us a discretion to extend the statutory deadline and avoided cost dockets where there are contested cases and where our expert tells us that they need more time to submit discovery requests and to conduct a more thorough investigation of the factual issues in dispute. Would you agree with that?
yes, I would.
And would you go so far as to recommend that we seek that discretion from the General Assembly so that we don't find ourselves in a bind? Because that certainly could happen and will happen at some point unless we take action. Would you agree with that?
Yes, I would.
Thank you. I want to pick up on Commissioner Caston's colloquy with you for a minute, and I'm glad he brought it out. One of my concerns is that while PURPA, I think, has served us well, I'm beginning to see some trend lines that concern me, and I'll tell you what I'm thinking. I'm not going to specifically refer to the company, but I believe there's another docket where we have seen no power purchase agreements over the last 2-year cycle. And I know that there may be multiple explanations for that. One, of course, that we've been disrupted by COVID pandemic. Another is that we have tariffs in place on certain component parts that limit developers' ability to bring in supplies from China and elsewhere, India. We also have seen a dramatic increase in transportation and shipping costs. I think it almost doubled the last year or so. And so with all this going on, how is a developer even able to determine whether they can proceed under an avoided cost rate and make it bankable or even profitable?
So I think that's an excellent question, and let me just speak to the general challenges of the current environment, which is, in addition to all the factors that you cited, I think that there are also uncertainties with regards to certain federal policies that have a direct impact on project economics. And so whether we're talking about the step down in the ITC or other you know, changes in the tax system that might impact your ability to raise tax equity, there is a significant amount of uncertainty that is kind of outside of the framework of the avoided cost proceedings, which would cause people to pull back a bit. I think any capable developer is always going to be trying to pull together opportunities that they can capitalize on once the landscape becomes more certain. But ultimately, you're constantly going through a series of calculations, right? You say, okay, based on what I know, does this project, meet my hurdle rates, right? And so what do I know? Well, after this proceeding, I will know what the avoided costs are that are allowed. I know what the current law is. I actually don't know when I'm going to get my panels. And I don't know, unless I've already contracted for them, which I'm not likely to have done if I don't have my avoided cost rate settled. I don't really know all of my costs. And so that would cause me to wait until those things were more certain. Now, you know, in an RFP process, because a request for proposals is going to get not the avoided cost of the utility, but it's going to get the cost of what the next project is that somebody actually wants to build. And that will factor in most of these things, or it might have pricing that said, you know, if the ITC is X, then my pricing is Y, and if there's a change, I'll be able to share some of that benefit with you, and that would all be laid out in the RFP. Whereas in an avoided cost proceeding, all you know is basically when does the utility need its next peaker, and what are our estimates of the cost of that peaker in X year. All of which, by the way, when we get to that year, might be affected by some of the same trends, right? So we've got, nobody can say for certain what the cost of a peaker in 2025 or 2026 is going to be. So I think that you know, the past 2 years have been challenging, even with the most cooperative utilities and a clear avoided cost rate. You could have a number of reasons why you would have no applicants under the avoided cost rate.
And so we actually had one of the parties, maybe several of the parties, ask us in our IRP docket to consider request for proposal for solar on a bid process, and we didn't take any action on it. But does that seem like maybe a reasonable step if we can match it up with the integrated resource plan? And of course, it also would benefit the company by meeting their goals in terms of becoming carbon neutral. Does that make sense as a possible step forward, so that we could then put it to bid, have an independent administrator take the low qualified bidder and then use that as a process to supplement what we're doing now?
Yes, I think that would be a sensible way forward.
And is that something that you would recommend that we consider going forward?
Yes, it is.
Okay. Does your firm perform the duties of an independent administrator in that type process?
Yes, we do.
Okay. So you're familiar with it, and or at least your firm is, to the extent that if we needed those services, you might be interested in bidding on those or services.
Yes, we would be.
Great. The final area that I wanted to cover with you is kind of a big picture look at our process in terms of our inability to communicate with our own expert. That's troublesome and problematic. So I'm going to pick your brain a minute and just ask you, do you think that there's some workaround that would still allow us to be in compliance with the ex parte rules that our General Assembly has imposed on the Commission, while still being able to give you the information and direction that you need to complete your independent evaluation?
It's an interesting question, given the nature of ex parte, and so first of all, I think there should be a way to separate administrative and substantive, such that the administrative were exempted from ex parte, right? I mean, things like, did we get the login, right? Having that go to everybody on the docket, that seems unique to me. I think from a substance perspective, if you're still bound by ex parte, I think that at a minimum, in terms of being able to highlight areas of potential interest in the report, that and I hope you don't lose patience with my analogies here. The way that I see it now, it's equivalent to having a home inspector come to inspect a property and not being able to tell them, by the way, I want you to look in the attic, right?
Exactly.
So a home inspector will do a thorough job, but they may or may not hit the things that you're most concerned about. Whereas if you can say to them, I want you to do a thorough job, but by the way, we are particularly struggling with, whether the attic is structurally sound, and we want to make sure your report addresses that. I think that it would be reasonable at least to have the ability for the commission to shape the report to make sure that at a minimum it covers the topics that you want to see. And to a certain extent, I can imagine that in a proceeding where you've gone through 5 days of testimony, something may have arisen which you'd say, hey, that's a topic where I actually want to make sure that the consultant spends, you don't have to dictate the number of pages, but gives us some thoughtful answers.
I agree, and that would especially be true in a contested case, true?
Yes.
Okay. So in terms of improving our process and procedure, how would this work? Once you're engaged, we could have an on-the-record discussion with you and all parties and their attorneys. But our conversation would be directed to you and giving you instructions on how we would like for you to highlight your report and focus your report given the time constraints. You think that might be helpful?
Yes, I do.
And there would be no opportunity for cross-examination because that you're working for us, but the parties would have confidence in the fact that we're not dictating an outcome. They would have, we would be transparent. Does that make sense?
Yes. I mean, I always hesitate to wade into legal proceedings, but I can imagine something where you give us instructions on the record. Parties would have the opportunity to object if something was inconsistent with the law.
Correct.
You know, they're not going to say, oh, you know, oh, Mr. Goulding, are you really capable of this? You know, how many VIC studies have you done, for example? But they could object procedurally. Then, you know, we go away and do our work. And obviously, we're subject to cross-examination on the results, but you know, not on the content that we've been directed to provide.
Correct, and that would continue to ensure transparency, accountability, and protect everyone's rights. Don't you think?
Yes.
And likewise, if we end a session where we have a highly contested issue and it comes down to really one or two issues that the commission feels like it may need more information for making a final decision, could we reconvene that same type of meeting with the independent expert and say, you know, we're satisfied with everything we've heard except for X. We'd like for you to go back and re-examine this based on such and such. Does that seem like a reasonable way to protect everyone's rights, but also give the commission at least an opportunity to give you some direction and guidance?
It does. The only caveat that I would make is that whatever guidance the consultant would receive has to be consistent with the time frame that they have to address it. And so,
and this brings me back to the final point, is that we really need to look at the time constraints, because we don't want to unnecessarily drag it out, but by the same token, we want to have a thorough review where warranted. So that's just common sense, right?
Yes.
Thank you very much, and I appreciate your report. I thought, given the short time frame that you had to work with, it's excellent work, and I think that's also demonstrated by the fact that none of the parties or their attorneys have any questions for you, or at least they didn't initially. So congratulations on the job well done.
Thank you.
Further questions?
All right. Are there any more commissioner questions for this witness? Okay, hearing none. Mr. Goulding, I just wanted to make sure that I ask you this because it was referenced a couple of times, the limited amount of time that you've had and the fact that you did not make discovery requests. Just want to make sure that despite the time limitations and not making those requests, your report, you still think that you were able to reach a reasonable conclusion based on the facts and evidence that you reviewed?
Yes, I do.
Okay. All right. Is there any cross-examination? Okay. Hearing none, I'm going to turn things over to General Counsel Wessinger Hill to talk about where we expect the parties to go from here.
Thank you, Mr. Chairman. Since this is the, this would conclude the hearing, the next discussion would be setting a proposed order date for any party who wishes to provide a proposed order. I had a chance to preliminarily discuss this with all the parties by electronically as well, and it appears that the 15th of October is an acceptable date for the parties to provide any proposed order for those who wish to do so.
Okay. October 15th is fine. The final decision is, could you remind me of the date?
Yes,
or
sir.
a deadline, I should say?
By statute, Mr. Chairman, the commission is required to make its decision no later than November 16th of 2021.
All right. Sounds good. Okay, if there's nothing else from the parties or the commission, we are adjourned. Thank you.